Okay. Hi, everyone. Thank you so much for bearing with us and waiting. We had a few technical difficulties, and we are running without a slide deck that we anticipated, but that's okay. We're here and we're going to give you the updates that you need to know. And if you don't follow anything or if you want to discuss this further, we're always happy to talk more about it afterwards. Feel free to get in contact with our firm and we'd love to discuss more. So before we get started, I'd like to introduce myself and Justin here as well. My name is Julia Cantu. I'm a Baylor lawyer licensed in Texas. I'm located in Austin, and if you're ever in the Travis County area, DFW, San Antonio, please connect with me. Let me know. I'd love to come out and visit you. I'm happy to travel to you as well. Our presentation here is called Navigating Medical Weight Loss Compliance. And this is because more and more it feels like we're in uncharted territory and there is no map. So I'll hand it to you, Justin, for a second to kind of introduce our firm, what we do, and how we can help.
Yeah, so I think Julia's being a bit humble. Julia has literally positioned herself as probably one of the experts in the country at this point on, not to prop you up, hype you up too much, probably has become, one of the experts in the country on this because she is constantly talking to the FDA, talking to state, licensing boards, pharmacy boards, very involved in the discussion, as many of you folks, online here probably are as well. But we're just, at this point, the FDA is probably on speed dial. And so she spent a lot of time, we spoke, recently at a couple conferences, and Julia's really kept abreast of all the changes, which, as you all probably know, this has been a crazy game of tennis back and forth as what's happening with shortage and no shortage and lawsuits and no lawsuits. So our firm, to touch on that, we do focus in medical aesthetics almost exclusively at this point. We work in healthcare specifically, but it's almost all med spa at this point, aesthetics and wellness. And so we do a lot of compliance work. We do a lot of mergers and acquisitions, which is basically all the folks who are getting phone calls from, PE groups looking to buy your very successful spa. We do a lot of those transactions as well. Obviously, a big component of what we're doing now is exactly this, trying to help you all work through changes in regulations and what's happening in the weight loss world. And just to pause or even to back up further, this is kind of our first official office hours. And so we do this, so we'll be doing this on an ongoing basis every month. It is intended for our members, which we have, a membership model, and it's pretty cool. But we wanted to open this one up to the larger group because there's just so much confusion and fear out there, I think, as to what's happening. So I think Julia, like I said, I'll kind of kick it over to her. We've been having all sorts of technical difficulties. So if one of us freezes or drops off, let's hope it's me and not Julia because she's the knowledge expert. But we can get it going.
Yeah, and then hopefully at the end, we'll be fielding some questions as well, and we can touch on some of those. So as Justin noted, this time has been very frustrating for a lot of our providers. We understand that. There's no shortage of headlines. We've been keeping track of motions, complaints. It's crazy. But there's a couple of things, right? Your patients need clarity because we need to know as soon as possible and give them timeline on if pricing is going to significantly change. We need to know when that's happening. You need clarity, and I hope that we can provide you some of that a little bit more today. So just to give you the scope of what we're going to be talking about, we're discussing semaglutide and tirzepatide injections. There's a whole world of GLP-1s. There's also oral medication. We're not talking about that today. We're talking about semaglutide and tirzepatide injections, both of which formerly were on the FDA shortage list. Semaglutide still is. But so just to kind of lead with the answer, and it's more complicated than this, but tirzepatide is now no longer in shortage on the FDA's drug shortage list. The status of it is resolved. And that means a lot of things right now because, as most of you know, there's been lawsuit updates, and so that's not the end-all be-all. But we'll talk about that a little bit more. So I know that kind of the meat of our discussion is going to be the new FDA lawsuit. Totally agree with that. But I just want to back a little bit into the answer and talk about the shortage list for a second, because I think it's important that our clients know how to read the list, address it, and understand really the terminology. So when you Google the FDA drug shortage list, you're on the FDA site, it's one of the first things that comes up. You can put in the search bar that they have there for drug shortages, tirzepatide injection. And what you'll see now, as of October 2nd, is a resolved status for the drug shortage. So as we know, that means officially that tirzepatide is no longer on the FDA's drug shortage list. They make that determination based on various different factors, but it is indeed, that's still the classification, as opposed to semaglutide, for example, which is still going to be classified as currently in shortage. How the FDA came to make that decision is really controversial and is the subject of that new lawsuit. So what I want to kind of point out here before we move on, though, is that is our firelight, essentially. Like, we're in the dark here. This is uncharted territory, but what hasn't changed is that we know that tirzepatide's status is still resolved. And the reason why we're talking about that and making a big point of that now is I want you to know that you can still access that drug shortage base, understand what's going on there, and reference it for other drugs. But I guess moving on, because just as soon as that came on resolved status with the drug shortage list, then we had a lawsuit filed on October 7th. So I'll skip forward to that a bit. I might be jumping around a bit here. But so essentially on October 7th, we have this lawsuit. It's called OFA v. FDA. OFA is Outsourcing Facilities Association, and they represent 503B compounding pharmacies. It's important to note that not all 503B pharmacies are part of this association, but they do represent them. So who's the plaintiff in this lawsuit is OFA. They have their members, they represent them, and they sued the FDA. So they sued the FDA for a couple of things. We're just going to touch on that really quick. So the lawsuit was filed in the U.S. District Court for the Northern District of Texas. The judge was Mark Pittman, I believe. And the OFA was seeking a determination that the FDA's action, taking tirzepatide off the list, was contrary to law and to have that vacated immediately. They cited different things, being that the process for removing this drug from the list happened with no notice, and there was no public comment period for people, compounders, providers, to provide their input. We know that would have been valuable for the FDA to know, right? Because a lot of different providers are telling us, well, it's off the drug shortage list, but we still can't get it for our patients, talking about Eli Lilly's drugs specifically. So essentially, the OFA sought a temporary order that would stop the FDA from taking action against OFA and its members for making compounded versions of tirzepatide injections during the pendency of the lawsuit. So what happened a few days later, there was a unopposed motion for remand and stay of the litigation in the Northern District of Texas. The FDA filed for this. The reason why they did that is they were like, whoa, we have all this complaint, kind of understand where they're coming from. We need to back it up a little bit. We're going to reevaluate our decision. And during that time, the FDA said a couple of things. It's going to reevaluate its decision, and it won't enforce violations for these particular regulations against the plaintiffs and their members, OFA and the members of their association. That is what's stated in the motion for remand. And that's actually public info. You can look that up and read that filing there. But the FDA has since clarified, and we actually saw this later on yesterday, that the FDA had sent a letter to the Alliance for Pharmacy Compounding and another compounding association, and clarified that it will treat all compounders, 503As, compounding pharmacies, and 503B outsourcings, as they're going to treat them all consistently during the time period of them reevaluating this decision and 2 weeks after they make their decision. So essentially, where does that leave providers? We have a couple of things going on. So the FDA has clarified that they won't enforce 503A and 503B compounding regulations against compounders during this time period when they're reevaluating their decision and 2 weeks afterwards. We've got kind of that safety or grace period. But there's a couple of things we want to note in this. So this is a letter that was sent to this Alliance for pharmacy compounding. I don't want to say that you can't take the FDA at its word. You can, and that they won't enforce these particular violations. But they noted that this is no claim or guarantee that the FDA themselves won't enforce other violations that are unrelated to the lawsuit. And they cite the particular regulations of 503A and 503B that are concerned with the lawsuit. So they won't enforce that, but they might enforce others. So it's not really, you have to still consult with legal counsel and be careful about what you're doing, because there's a certain carve out for what's okay for compounding in the meanwhile. And mainly what we see with our different providers that are prescribing compounded tirzepatide is that, yes, during this time period, until we see clarity, until the FDA reevaluates their decision, you can continue to prescribe compounded tirzepatide. And that's really good news for our providers. However, here we have the slide deck.
There's our deck. So Julia, while that's getting pulled up, just to interject here. Sorry guys, this platform is new for us, so we want to make sure. We were having technical difficulties pulling up the deck. While it's getting pulled up, to put it in layman's terms, and maybe you're going to get to this, right? But for the non-technical folks there, including myself, because you're so far ahead of us on this, basically we get a lot of pushback, right? We're like, people are like, it's still on the it's resolved, right? And people are like, no, it's back on the shortage list. And we're like, actually, it's not back on the shortage list.
Right.
Like asterisk, right? There's like this exception kind of scenario. So just to kind of repeat it, it's still resolved, right? I think you might talk about what that means. But there's kind of this temporary situation where the FDA is like, listen, we're reevaluating if it's really resolved or not. You can kind of do your thing, compound, but like so it's not technically back on the shortage list, but there's right now like a bit of a workaround. Is that accurate?
Yeah, that's a good summary. That is what's happening. And let's back up a bit, right? Because why does that even matter? Like, what is the drug shortage list and why is that important? So the reason why our interpretation of this, right, is that we're still using the drug shortage list as our firelight, as our guide. Why is that? It's because that is what's in the statutory, the code for the FDA regarding, and this goes, I mean, this is all the way back to like, we're talking about patent enforcement and how compounders can make essentially copies of commercially available drugs. That's how, this whole thing started, right? We can't compound tirzepatide or semaglutide without having a drug that's on the drug shortage list, because we're talking about Novo Nordisk and Eli Lilly, and they have compounds for these, or they have patents for these drugs. So that's why, and we've had shortages of these drugs since 2022. So it's been the norm for a lot of people, for a lot of providers, to have these compounded versions of these drugs. And according to the statutes behind this, you can have a compounded version of a commercially, or if a drug, if it is not commercially available. What does commercially available mean? And this is in our slide deck as we're going through like parsing out these definitions that are so tedious. But commercially available means that it's not on the FDA's drug shortage list. So it's sort of circular in the logic, but it's in the code that if something is commercially available, then people cannot make essentially a copy of commercially available drugs in inordinate amounts, in large amounts. And the reason why they can't do that is because this runs afoul of patent enforcement and the patents that Eli Lilly and Novo Nordisk has on their drugs. And so it kind of goes back to like, we want to make sure that patents are still safe for people, that it's worth the squeeze for people to go through the R&D to develop these drugs. It's a very big picture. So that's why the fact that these are classified as either resolved or currently in shortage is really important, because it goes back to the law and how it's written. So to make a long story short, could all of this change? I mean, I don't want to throw another like wrench in there for our clients and having to understand this, but this is a big deal that the FDA chose to reevaluate its decision, because it feels like we have like a tug of war going on between the compounding pharmacies, and Eli Lilly is on this end, and the providers and the patients are in the middle, and they're trying to enforce their patents. Compounders are trying to provide drugs at commercially, reasonable prices for people and to address that shortage. But it feels like the FDA gave in a bit to the pharmacies. Hopefully what we do not see, but what might happen is just a tug back in the other direction. I mean, who knows what the manufacturers are going to do in response to this, as we know they have big lobbying, it's going to be big, the response. So I would have said that I would have expected the FDA or Eli Lilly to sue the FDA before the compounders, but it just kind of happened to be that that's because they made this decision to take it off the shortage list when it's not that we didn't see that coming, but it seemed to happen sooner rather than later. We didn't necessarily expect that in Q4. So that's a long-winded way, Justin, of getting back to why does this matter?
I think that's super important for people to know, because we talk to clients every day who are pretty frustrated, and I think we get it, like, just as much as you all do, who are literally in the spas and in the wellness practices every day. It's super frustrating to not, even as lawyers, right? Like the worst thing, what does your lawyer say? It depends, right? I have a hat my wife bought me, says it depends. It's obnoxious, and we don't want to give that answer, but this is all unfolding so quickly that literally by, a day from now, 2 days from now, there might be an update. And so I think, Julia has some thoughts probably, on like going forward and maybe ways to plan and be prepared. I don't put words in your mouth, but, we've talked about some things that our clients can do. But I think at this point, like, it's just really trying to stay informed. And please, please, please don't go off of what you heard from, an online forum or, from so-and-so. Like we're, like I said, Julia, we're living this every day with you guys, but I think it's important to stay informed of like with the real facts and not like erroneous information. So it really has. I mean, tug of war, tennis, ping pong, like whatever it is, it's going back and forth. And we're in uncharted territory. I mean, this is kind of stuff that like law school books will geek out on down the road as far as what's happening with this battle of, of power.
I'm geeking out right now. Like,
love hate, I guess. Julia, do you want to touch on, or did you kind of have planned? Again, I know we had our deck pop up, it disappeared. As far as kind of the go forward strategy for people, what are your suggestions on how we prepare for whatever's ahead?
Yeah, absolutely. And I want to take a moment to touch on one big thing as well. So I hope people haven't like tuned out, like this is the moment, tune back in, because this is important. So Eli Lilly, there's a couple of things, right? I know people got letters a while back, like we're talking about August, where those letters were basically toothless. That was our response to that. We knew that what they were stating was incorrect based on the statutory interpretation. So, and accordingly, right, they pulled back. People, unless there were other violations involved, we haven't heard much from Eli Lilly, except for, right, that kind of generalized letter they sent to people regarding compounded tirzepatide. Don't market it, don't distribute it, don't prescribe it. So all of that, right? And a lot of people, we know a lot of folks didn't respond to those letters. That's all right. And it's also not too late to engage counsel to at least be there for the next, hopefully not, but next time if you do hear something from them again, because obviously this is crazy. We're all getting whiplash from this. But so this is important, right? So now we have this OFA v. FDA. The FDA says we won't go after the compounders during this time period, that we're reevaluating our decision, their members, any of the compounders, really, OFA, their members, and just generally now on the 21st, they expanded that and said, hey, we have to be fair to everybody. So now compounders are kind of in the clear. But nowhere in any of this did they mention Eli Lilly, because they can't. Eli Lilly was not a party to this lawsuit. They can't hold Eli Lilly to any, this motion to remand had nothing to do. They're evaluating their decision has nothing to do with Lilly's ability to enforce their patent rights, especially because based on the law, the drug shortage is resolved. So they said that the FDA won't enforce something, but from our understanding right now, this does not stop Eli Lilly from enforcing this. And I'm sure that Lily's cooking up something right now trying to respond to this, because this is a huge gap in the situation, okay? We have the FDA, compounders. The FDA enforces typically only in really, grievous situations. Eli Lilly has a way bigger incentive to enforce this against people based off of their bottom line, right? So I think that we want people to still be aware of that. This is continue to compound. At the same time, you want to be aware that any notification from Lilly, technically they have a leg to stand on at this point, because it's off the list. That's what the law says. And it could be any day that we see Eli Lilly push back and sue the FDA for basically standing in the way of them enforcing their patent rights. So at this point, this is a gray area. From the letter of the law as it stands right now, Eli Lilly can still enforce these. Because there's so much gray area with the FDA, we don't know what they're going to try to do next or what their next move is. But so that brings up a good point, right? Like, we want anybody who's receiving a letter at this point, please have legal counsel review it, just for your own peace of mind. We don't know what's in these letters. We believe that, there was this round in August that was very cookie cutter for everybody. Things could be very different at this stage. We know that they've been gathering information on different providers and compounders, requesting patient information in some cases. And there was a couple of lawsuits that came out yesterday or early this week that Eli Lilly did sue a couple of compounders and med spas, not related to this lawsuit though, and actually not related to compound tirzepatide in general, but other violations of the patent in different ways. Have to do with advertising, a case that had to do with oral tirzepatide tablets, which those are not on the shortage list either at this point, right? So different lawsuits that have to do with different things, but each case by case is going to be different. It really depends. We want you to get that letter looked at if you received one, especially recently. And so that's our recommendation. We can't say broadly, like broad strokes of whether everybody should respond to them. But I think generally we don't recommend that clients respond to them individually. Hopefully you can get legal counsel to respond for you, if not for any other reason than just to have, if you send a letter back from your legal counsel to Eli Lilly, then they have to contact your counsel from there. And your counsel can help interpret things. You'll just have somebody, on your side, peace of mind, during the situation. So that's a big note about the legal notices. And just to kind of switch gears, I guess, and talk about semaglutide, for example, as it stands, right? So semaglutide injections are still on the FDA's drug shortage list, although most of their presentations are available, if not all of them at this point. So again, it's a very similar situation with semaglutide. We could see that coming off the drug shortage list, and then have compounders do the same thing, file another lawsuit, get another reevaluation of the decision. That's why I highly doubt that will be coming off the list without until we get this reevaluation of the tirzepatide. But we don't have a crystal ball, right? So it's certainly possible. And of course, there are other GLP-1s that are on the shortage list that people are interested in, and those are going to have to be just on a case-by-case basis that you review with counsel about that. So going forward, right, into 2025, this has been such a roller coaster. Hopefully things kind of cool down around the holidays. That wouldn't surprise me if we kind of have a gap of hearing about this for a while, although my Google alerts have been going crazy for the last couple of weeks, just trying to keep up with all the different news. But so I think that 2025, we're going to see Novo Nordisk also racing to get off that FDA shortage list. Unfortunately, right, I think we want to prepare our clients for the possibility that the price of these drugs is going to skyrocket. I know we've seen different congressional hearings and discussions about why are these drug prices so high, but that is at such a higher level. Who knows if they're is going to be any action towards lowering the prices of these drugs. That's a whole nother story, and would take many months to get resolved, right? So I hate to leave you with some ambiguity still, but just to wrap up and to kind of reinforce the bottom lines that we've stated, right? Tirzepatide is off that drug shortage list. The lawsuit has been remanded, and there's a stay on the litigation. The FDA is reevaluating its decision. It made no promises, but during the meantime, all compounders, as they've further clarified now, can continue to compound tirzepatide injections, but they are not free from FDA enforcement on other violations that are not related to tirzepatide compounding. Eli Lilly is not a party to this lawsuit. We don't know what they're going to do. Well, we do know what they're going to do. They're going to try to enforce this to the maximum extent that they can. And what that looks like is not entirely clear. We know that they've sued a couple of people earlier this week based on things that were unrelated to this lawsuit. But we'll continue to monitor the situation and let you know as soon as possible. But we do have guidelines and recommendations for best practice for our providers who have weight loss verticals. And we want you to talk to us more about this. We'd love to share those with you, but we just need to know a few more details about your practice in order to comprehensively strategize for your business. It is a case-by-case basis. I really feel like every practice is different, but we'd love to hear more from you. And yeah, I wonder if we have
someone had a really good question. And by the way, folks, like you can pop in. There should be a question box, I think, on the lower right.
Mm-hmm.
So I don't know if you can see it as well, Julia, but basically, someone asked, if we aren't advertising or prescribing compounded tirzepatide anymore,
Mm-hmm.
I guess they're still offering it, but if you're not, although it says, no, we're not prescribing it. So basically, do we have anything to worry about? It sounds like they just got another letter. So maybe they were, utilizing compounded. Now they're not, I think, but the letters are still coming.
Yeah. So we'd want to see that letter, not to give you, a canned answer there, but we'd want to see the letter 100%. Compounding, right, or prescribing compounded versions. To be clear, you can continue to do so for the time being, but from Eli Lilly's standpoint, right, I really would like to see the content of those letters. They typically sometimes will give you a citation to an FDA regulation, and based off of that, we can kind of figure out what they're alleging and take it from there. Whether they warrant a response or not, it's really going to be a case-by-case basis. And just to kind of, I guess, clean up that idea, right? So you can continue to compound, but we want you to know that there's still risk from Eli Lilly. Hence, you might continue to receive letters. And so this is just going to be, I feel like, truly a cost benefit analysis for a lot of businesses. We can tell you what's going on and what the risk is there. We know from, the FDA, the risk is low or non-existent at this point. Eli Lilly, still a little uncharted. So hopefully that answers the question to some degree, but we'd really like to read those letters specifically before giving you a clear answer there.
Julia, from an advertising standpoint, so my new BFF, Brandon, has a question. Thank you, Brandon. We love you. So he's asking if we should take the language, right? Tirzepatide, with like we're offering that. Should they take that off the website and, service descriptions, or are we not there yet?
Yeah, I have mixed feelings about that because I think that legally speaking, right, if it's compounded tirzepatide, that's the phrase we were talking about. You might want to get a little bit more specific and say injections, but also there's nothing against you using that phrase right now, as things are still on the FDA shortage list. But best practice, I do feel like to some degree, and I don't want to be like a conspiracy theorist, but I do feel like having this on your website does put you at a little bit more of a risk. I feel like we don't exactly know how Eli Lilly has gotten some people's contacts for the businesses, et cetera, but it's really easy to Google compounded tirzepatide in my area and find, different businesses that are offering that. So it's kind of up to your risk tolerance. I think for that reason, it might be helpful to remove that, but you're not required to.
So That's a great question. I'm like super excited to ask you the next one because we get this all the time. So this is like suddenly turning into a Q&A, so I hope you don't mind. All right, so somebody asked, what is the compound? So what if we're using the compound? I'll translate it. What if we're using compounded version, right? But we add B12, we add something to it. And now a lot of our folks ask us this all the time. They're like, well, now it's no longer the same thing. And, can I do that? Because it's no longer, and you have a really good answer, I think, to this.
Yeah, I really like this question too, Justin. Yes, because so I know not to get too excited about, I'm like, nerding out. But yes, so the answer to this is that it's still considered to be essentially a copy of that commercially available drug. And this is unfortunately in our slide deck in a very nice like 1, 2, 3 format that people can see that's helpful. But again, we're happy to explain this afterwards as well. So if you go to these, and this is Googleable as well, the FDA's 503A in guidance or 503B guidance, there are those 2 documents. They're like big PDFs. But what's helpful about them is at the bottom of them, there's these charts, right? And I really like these charts. They say, what is essentially a copy of a commercially available drug. That is the problem of what you can or cannot compound. We know commercially available equals not on the drug shortage list, right? So then step 2 of the analysis is, well, what is essentially a copy? And to kind of get to the answer, I could go on and on, but so what is essentially a copy? 503A and 503B, they have very similar definitions. There are 3 prongs to this. It's similar API, and that's the important part to answer your question here. We have similar API, same or similar dosage, and same route of administration. Route of administration is out because we have injections. It is what it is. So then the other one, same or similar dosage, you can kind of play around with that, but the FDA has said that anything within 10% of a dosage that's offered by the manufacturer is the same or similar dosage. But what people really need to pay attention to is same active pharmaceutical ingredient. So active pharmaceutical ingredient, API they call it, being semaglutide or tirzepatide, right? So tirzepatide injection, for example. Long story short, same API. You cannot add B12 or other vitamins and whatnot. You have the same active pharmaceutical ingredient. It is therefore still the same, essentially a copy of a commercially available drug. So therein lies the problem, right? API, there's no, and also the definition of compounding, right, is adding, mixing, anything like that. So that's still compounding a API that is essentially available. So unfortunately not when you add those extra ingredients, that is still considered to be a copy of the FDA's, if the drug is not on the shortage list, then that's not able to be compounded.
Yeah, so we've got this question so much. Can I offer it in a different, I don't know, a means of offering it, right? Can I change the vial? Can I change, the substance of it? Can I add B12? Like we get this all the time. And so it kind of sucks, everyone, because like, we'd like to be able to tell you, yes, now you've changed it and you can administer the compounded version. But like Julia said, it's essentially, the same thing.
Yeah, that's all compounding, right? Even like changing a vial and turning it into a syringe or something, things like that. That's also compounding.
Right. And so trust us, guys, like we are constantly spitballing ideas with a lot of, our clients to see what could work. I think the facts kind of are what they are at this point. I guess we could do, I don't want to bore everyone, but we've still got some people on here. The question, this is pretty interesting, Julia, and then maybe we'll wrap. So what about, and actually we get this in the context, not of just prescribing, these drugs, but the question is, what about prescribing non-FDA approved weight loss peptides, right? Like other things that are not FDA approved. Where do we, I don't know, your thoughts on that?
Yeah, so anything that's non-FDA approved, right, you have limitations there, and you can't say certain things about the medical effects of these treatments if they're not FDA approved, and you can't advertise with certain medical claims. So you have to worry about then about kind of the marketing and advertising of those treatments. You can administer them to your patients, absolutely, but you're just going to need to also, we would recommend including your consent forms, language discussing the fact that it's non-FDA approved. There are many drugs that are, non-FDA approved that people are using. Talk about all kind of different hormones or things that are, we see this with like BHRT, different combinations of things. So that's okay. And one kind of, I guess, side note is that any compounded drug in general, there are no on or off label uses of that. So we see questions about that too, right?
Yep.
Is there a off-label, on-label, off-label prohibition against compounded drugs? But that's kind of like a negative question, right? Because there are no on or off-label uses. All compounded drugs are considered to be, I guess, off-label in a way, in that there are certain risks associated with them. Just want to always address that with your patients and make sure that's reflected in your documentation as well. Best practice, just to protect your practice.
Okay, awesome. Well, I don't want to, we've got some other really good questions that I think, if people have things they want to talk to us about directly, we're available. We're obviously, on top of this stuff all day, every day, again, particularly Julia. So, we can set up a consultation. We can kind of do it. We do a lot of times a compliance assessment. So we'll kind of take a deep dive into your practice. And again, we do this with our members. We do this with other clients. Take a deep dive into your practice. Certainly we can focus on weight loss, right? And we're able to evaluate like where we see risks. And we're not consultants, but obviously we're in the space quite a bit. We work with some of the best, I think, fractional CFOs, advisors. We kind of know all the players in the space, so we can always kind of get a team together to help advise you. Because I do think, like, I guess I'm a business owner with the firm, but having owned kind of a dental group prior, I don't want to just be the lawyers who scare you with all the negative things that can happen, but rather like, let's actually plan how to position your business to continue to be successful after these things potentially happen. So I think, we can kind of give you the good, bad, and the ugly, but let's also talk about strategy going forward and how to keep you, hopefully compliant and successful and growing. We've had a couple of questions that have come in about where we're located. So probably should have mentioned that. Apologies. We are nationwide. I'm in Connecticut. Julia's in Austin, Texas. We've got attorneys in California, North Carolina, New York. We're constantly adding, people to our team. It's been a really cool, ride working in medical aesthetics because you guys keep us busy. But really, whatever state you're in, we'd love to chat and take a look. And again, we have our membership model. If that's not a fit for people, we kind of do flat fee type of work. But it kind of starts with like, if you're a new client for us, we want to do a compliance assessment, take a deep dive. And I think, again, there's no better person to talk to right now in the country, in my opinion, on this, other than Julia, who, is really up to date. And as things are changing, we are kind of sending out newsletters. We try not to like bombard people because it's changing so quickly. But again, don't hesitate to kind of ping us with any questions. MartiLawGroup.com is the site. We're on social, at _ Marti Law Group on Instagram, LinkedIn, and certainly, our emails are Justin at Marti Law Group, Julia at Marti Law Group. So feel free to ping us. And Julia, I don't know if you had anything else. I just wanted to kind of throw that in there so folks know how to get us.
Yeah, no, I think we touched on it all, Justin. I'm just looking at, my slide deck here, make sure I didn't miss anything. But no, I think we covered it all. It's just that the situation is always evolving. So don't, we will keep in touch, and we do, as Justin mentioned, reach us at our website. We also post blogs about this and try to keep up with the news as it comes in, and we'll write pieces that reflect on that. But again, we'd love to just talk to you and hear more about your specific practice and situation, because I think that everybody's different. And I think it's no longer safe to assume that these letters are generalized across the board. I think that we need to take them seriously, make sure we're addressing our clients' needs as they come. And also, also just be there for folks as these might start to come in at later dates. And we'll keep you guys posted on everything. Yeah, so I think that's all I have to cover, but who knows, that could change tomorrow.
Yeah, seriously. And guys, this should be a recording you get. This is, again, we're trying to figure out this software. You should get a recording of this, because I know like my phone's been blowing up, like people like, I didn't know it was right now. I wanted to catch the talk. So we should be able to, you should get a recording like automated from the system. If you don't and you want the information, hit us up and we can kind of disseminate that. But Julia, thank you so much. I know I like grill you with these questions on the spot, so appreciate it. And I'm sure everybody else does too.
Yeah, I hope we're going to probably do one of these again soon. So we will see you all soon.
All right. Thanks, everyone.
Okay.